Hi, Phil Silberman with the Silberman Law Firm here today. This is part of our real estate financing document series. So this is the promissory note. We have another video where we've gone over the warranty deed with the vendor's lien, another video where we've gone over the deed of trust, which is the equivalent of the mortgage in Texas, and this is the underlying note, the promissory note in a typical real estate transaction. So let's go ahead and get started. You've got the title of the document, promissory note. Sometimes you see that as real estate lien note. Notice there's no notice of confidentiality rights up here in the header like you have in the warranty deed or the deed of trust. That's because in Texas, the promissory note is not usually recorded. Then you get into the date of the note, who the borrower is. In an owner finance transaction, the borrower is also the buyer. The mailing address of the borrower, the lender, and again, in a typical small owner finance transaction, the lender is the seller who's also an individual. Place of payment, you may have a physical address, but you also have this language about any other place that the lender may designate in writing. So it could be electronic payment or whatever the lender wants to designate. The original principal amount of the loan, which is $100,000. The annual interest rate expressed in writing and as a actual numerical number here, 8.25. Note that I often get asked the question, what type of interest rate should I charge in an owner finance transaction? And my answer is lawyers really should not give advice on the business components of a deal. But at the time of this video, I think the rates on a conventional 30-year mortgage is probably 6% or something like that. So borrowers that are doing owner finance transactions typically cannot qualify for traditional financing, so they're going to pay a premium over what a borrower with good credit and good income could get in the regular market. So this could be as high as 9 or 10% if rates are currently at 6, maybe even higher. You need to be careful about accidentally making a usurious rate if you're going to do something crazy high. And you can check your usury rates online in the state of Texas. They're actually not the easiest thing in the world to check because I think the finance code dictates how they're published, and it's not, if you Google it, you just won't get usury in Texas is X%. There's different categories and things like that. So it takes a little know-how to figure out what your current rate of usury is for the type of loan. Maturity date, in this case, it's a 10-year. I did a 10-year loan that matures on July 1st, 2033. Annual interest rate, so matured unpaid amounts. Usually this rate is much higher because you want to penalize the borrower for having on anything unpaid. Sometimes you see language here that says the highest rate, the maximum rate allowed by law. That's okay too. Terms of the payment, principal and interest. This is a fully amortized loan paid out over a period of 12 years every month. So the principal and interest due is, in this case, $1,227. And some attorneys get confused on how to calculate this. I actually think it's better that the lender or the seller in an owner finance transaction go calculate this themselves and provide it to the attorney. The attorney drafts the documents, provides legal advice, but shouldn't really be involved in the business component. But if you're out there trying to calculate your monthly payment, you can just Google an amortization calculator. And I went ahead and did that. In this case, it's bank rate. And you plug in the loan amount there, the term, the interest rate, and then the start date, and then it will give you the monthly payment, as well as some other basic information about the loan. And if you go to schedule, you can actually see the full schedule of every payment, and you'll note that in the beginning of the loan, the principal the amount of principal being paid is much lower, and towards the end of the loan, the principal payments increase relative to the interest payments. So almost the majority of your interest is front loaded in a typical uh, uh, typical amortized loan, and then your interest basically slowly decreases. The interest component slowly decreases over the life of the loan, and then your principal component increases over the life loan. You can see the principal portion increasing here over the life of the loan, and the interest portion decreasing. So that's a little bit about the calculations behind the scene. So back to the actual legal document, the promissory note. Security for payment, that's typically the deed of trust, a vendor's lien, that outlines the real property here, and you've got the real property description in a real estate lien note. Promise to pay, basic recitation that the borrower is making the promise. In a promissory note, it's just the borrower that makes the promise, and that's why the borrower is the only one to sign the promissory note. If you're going to have a more complex legal document where the lender may be making some promises, then you're going to want to add a loan agreement to it as well. Defaults and remedies. This section lists what happens if a default exists. Usually there's an acceleration, and there's a foreclosure process that goes on. And then you've got some notice provisions in the event of default. So there are some requirements here and details of what happens in the event of a default. Attorney's fees. This basically is going to say that if the lender has to hire an attorney to enforce the note, the borrower agrees to pay for attorney's fees. Prepayment, it's important to know whether your note has any prepayment penalties, and most of the time the borrower can prepay without penalty is the standard setting in a residential real estate transaction. Application of prepayments, usually the standard is that goes towards principal first. How you calculate the interest. This gets pretty technical, but it tells you how the interest is actually being calculated. Usury savings clauses, these are typically enforceable in Texas. If the lender accidentally names a usurious rate, this clause is meant to save the lender from the ramifications of being sued for usury. Other clauses, this is what's called a full recourse note. So each borrower is actually responsible. So for whatever reason, the borrower doesn't pay and the foreclosure doesn't satisfy the full obligation of the note, the lender does have the right to go after the borrower in a deficiency proceeding, is what may happen. Late payments. So if the borrower is late, usually late on the 15th of the month, there's some kind of fee or charge here. And then you get some kind of boilerplate provisions, choice of law, state of Texas, because we are in Texas. The lender can provide and report to the credit bureaus, things like that. And the signature block signed by the borrower or the maker of the note. Remember, in Texas, notes are typically negotiable, and the maker goes ahead and signs the note. There's no acknowledgement clause here. I mean, you can have the note acknowledged in front of a notary, but it's not required. It just needs to be signed by the borrower. That brings us to the end of our review of the Texas promissory note. Again, my name is Phil Silberman with the Silberman Law Firm. Hopefully this video has been educational. If you have any questions, feel free to let me know, or let me know what other topics you might want to see. And as always, if it's something you like, remember to like and subscribe. I appreciate you watching.